Before I introduce our speaker, I'd like to just comment a bit about this series and about Dorothy Thompson, for whom this series was named. Dorothy Thompson, when I first came to K-State, was director of affirmative action, and she went to law school and became an attorney and became associate general counsel at K-State, and I became her most frequent client. So I knew her really well for a long period of time and worked together with her. And Dorothy was a lawyer's lawyer. When it came to understanding the politics, the canon law, meaning the faculty handbook, the policy and procedures and practices, and the civil law. She could always, in a nuanced way, put the politics, the canon law, and the civil law together into a workable whole, and in doing so, keep the interests of the individual and the university, or the parties, uppermost in her mind. And in both of those positions, and in everything she did, she was a constant advocate of civil rights, as you know, and that, in fact, was what primarily led to this series in her memory, because she influenced campuses throughout Kansas and, in fact, throughout the nation. The first lecture took place in 1994. Dorothy's tenure with the university spanned 30 years, from 72 to 92. And tonight's lecture is the 17th lecture in this series. So it's within that context that it's a real pleasure for me to introduce our speaker tonight, Marianne Wesson. Wesson is, among other things, a successful lawyer, a scholar, and law professor, and an author. And we're now a proud owner of one of her books, which we picked off the table out there, and you'll have that opportunity as well. I'm doing my best to move the merchandise there. As a trial lawyer, she prosecuted many federal criminal cases in Colorado Federal District Court, and later in her career was appointed to defend a death row inmate in California, Jerry Fry, to whom she dedicated her first novel, Render Up the Body. Wesson was inspired to write that first novel by her experience on both sides of the criminal justice system. And that book is about a former prosecutor and rape victims advocate who is appointed to represent a death row inmate. Her second novel, A Suggestion of Death, has elements involving the militia movement, underground illegal common law courts, and repressed memories, and was inspired by her experience as an analyst and commentator of the Oklahoma City bombing that took place, Oklahoma City bombing trials that took place in Denver. Wesson is a professor and Wolf-Nichol Fellow at the University of Colorado School of Law. As a law professor, she's been distinguished with the highest teaching awards and has published many academic articles on criminal law, evidence, trial practice, and law and literature, and also a treatise on Colorado criminal law. Professor Wesson has also contributed significantly to the debate about pornography and feminism and law. She has many scholarly as well as popular publications on that subject. The title of tonight's lecture is Chilling Effects, Cross-Burning Pornography and Censorship. So please join me in welcoming our 17th Dorothy L. Thompson Civil Rights Lecturer, Professor Marianne Wesson.
I can only assume that some of the students among you were here because some professor misguidedly offered you class credit for coming tonight. Anyway, it's great to see all of you. For those of you who were brought here by your devotion to the Dorothy Thompson Civil Rights Lecture Series, I just want to say what an honor it is for me to be included in this circle of affectionate memory and concern in the hearts of people who remember Dorothy Thompson with so much respect and who have so much commitment to the rule of law and the rule of civil rights. To be part of that enterprise is really touching to me, and thank you for making me part of it tonight. I want to talk to you a little bit about the connection between pornography and civil rights. I was interviewed this afternoon by a very charming young man at the student radio station, and he said to me, I've thought about this and thought about it, and I just can't see how there is any connection. So part of my goal here will be to try to explain what I see as the connection between the two. Let me start by telling you about an event that you may have read about already in the newspapers. This event happened about a month ago in the chambers of the United States Supreme Court during oral argument of a case called Virginia versus Black. Virginia versus Black is a case about whether the First Amendment and its guarantee of freedom of expression permits the state of Virginia to have a law against burning a cross with the intention of intimidating someone. So several men burned a cross, obviously with the intention of intimidating someone. They were prosecuted under this law. They were convicted. They've appealed their convictions to the United States Supreme Court, and their lawyer has just argued that although cross burning is hateful and intended to intimidate and a vestige of racism and slavery, even so, the First Amendment protects one's right to engage in this conduct because it's speech. It's not words, but it's symbolic speech. It's conduct that's intended to send a message, a clear message, and the First Amendment says, according to well-established law, including cases that say you have to allow people to burn flags to make a statement, it's well-established law that conduct intended to make a statement is protected by the First Amendment. This is the argument that's being made before the United States Supreme Court by the lawyer for the men who've been convicted of burning the cross. And Justice Clarence Thomas, who is well known among court watchers for almost never saying anything during oral arguments in the court, spoke up. And here are some of the things that he said. The government's lawyer, who is arguing in favor of upholding the law. In other words, the government's lawyer is arguing the First Amendment doesn't protect this expression, and he says the reason is that this is an attempt to intimidate. And Justice Thomas speaks up. And I wasn't there, but I'm imagining the looks of surprise on the faces of his colleagues and all the others in attendance. And he says, this was a reign of terror, and the cross was a symbol of that reign of terror. Isn't that a lot more than intimidation or a threat? And the lawyer's arguing really on Justice Thomas's point of view, but to Justice Thomas, the lawyer hasn't put it strongly enough. He says, this was a reign of terror. This isn't just intimidation or a threat. And Thomas says, there's no purpose to this conduct except to cause fear and to terrorize a population. And Thomas, who I'm sure you all know was raised in segregated Georgia, says burning crosses is intended to cause fear. I know this because we had almost 100 years of lynching and such activity in the South by the Knights of Camellia and the Ku Klux Klan. This was an extraordinary moment, and the other justices who in their comments up to that moment had seemed to be going in the direction of the lawyers for the convicted men and their First Amendment argument, because after all, the court had held many times you can't make it a crime to burn a flag. So how could you make it a crime to burn a cross? The other justices had been making comments that suggested that they were being drawn in this direction, but Justice Thomas's comment caught them up short. And if you look at the transcript of the oral arguments, you see the other justices then starting to say very different kinds of things. Here's some of the things they said. Justice David Souter says, the cross has acquired a potency that's at least equal to that of a gun. And then Justice Scalia says, in my opinion, blacks would prefer to see a rifle-toting man in their front yard than a burning cross. And then the lawyer for the men, a man named Rodney Smalley, he says, but Your Honor, this is just like burning a flag, and we know that's protected by the First Amendment. And Justice Ruth Bader Ginsburg spoke up, and she said, no, burning a flag is a symbolic attack on the government, but burning a cross, means attacking people, threatening life and limb. Okay, so think about that a moment and then put it aside, because I'm going to come back to it later. But I wanted to frame this conversation by talking about that moment in the United States Supreme Court not so long ago. Now, the next part of my talk is what I think of as speech, giant or wimp. If you go to many meetings of organizations like the ACLU, devoted to the protection of freedom of speech, and by the way, the ACLU has taken the position that the law can't punish either flag burning or cross burning. If you go to very many meetings of the ACLU, there's always an agonized debate about civil rights. Should we take the position that cross burning is protected by the First Amendment? It's a difficult issue for well-intentioned civil libertarians. But if you listen for long, the debate always takes a turn something like this. Someone says, well, no one was ever encouraged to go really hurt someone by someone else's speech. Someone else says, yeah, sticks and stones. Sticks and stones can break my bones, but words will never hurt me. And the conversation goes along in that direction. I know, because I've been to a lot of these meetings. And the general tenor of it seems to be like, speech is a wimp. Words are not that powerful. Words can't break your bones. Words are not really as potent as in our worst fantasies we give them credit for being. So we don't have to have laws that limit certain kinds of speech, because speech really can't do that much harm. This is a kind of conversation that drives me crazy, because I'm a person of the word. I mean, I'm not actually very good at anything else except talking and writing. If you had me over to your house to fix a faucet, you'd be very disappointed in the results. So I live by language and the word, and I have to believe that words are powerful. Words are, in this post-industrial economy, words and images are most of what we produce and most of what we consume. And the First Amendment is in the Constitution precisely because those who wrote it knew that words were powerful. It's not that they had to protect speech because speech is wimpy. It's that they had to protect speech because they understood that only speech can make us better and can move women and men to do great deeds. If you believe that, and I do from the bottom of my heart, that, for example, reading good books can make us better. Now, I know you believe that, because why would you spend all this time and money at an institution of higher education unless you believed that you were somehow being made better? In my generation, some people were there to evade the draft, but I know that's not why you're here, not yet. So it has to be because somewhere in your heart you agree with me that reading good books, exposing yourself to beautiful art, watching profound films makes you better, makes us better. If you believe that exposure to good speech makes you better, how can you not believe that exposure to evil speech makes us worse? You can't have it both ways. And it seems to me that the right way is that speech is no wimp, speech is powerful, and beautiful and good speech can make us better, and ugly and evil speech can make us worse. That's what I believe. That's not an argument for censorship. Please don't misunderstand me. It's just a request that you acknowledge the power of speech. I do believe that words can hurt you. Words can break your bones. Words can break your heart. Is there anyone here whose heart has never been broken by someone's words? And words can break your spirit. And words can also teach others to regard you as something less than human, which I think is at the bottom of Justice Thomas's observations on the occasion of the argument of Virginia versus Black. Words not only influence us, they construct us. The words that we say and the words that we hear are part of what makes us who we are. And as we grow through life and change, as I said, words are the greatest part of what we produce and what we consume, and the greatest part of how we make ourselves in our own eyes and in the eyes of those around us. All right, the next part of my speech is called bicycles. I have a friend, he's in the bicycle business. And we were talking about the bicycle business one night, which is mysterious to me because of the aforementioned problem fixing faucets and things like that. Like, if you had me explain how a bicycle works, it's really a little mysterious to me. So I'm always asking him questions about the bicycle business because I'm curious about it. And he was explaining to me once that if you were to buy a bicycle for, say, $400, about $60 of the price of that bicycle goes to insuring those who designed it and produced it and distributed it and sold it against liability for some harm that might come to someone because of that bicycle. And I was not shocked by the idea. I'm familiar with the idea that products have the cost of liability insurance built into them, although I was a little bit shocked by the amount. And I started thinking about this. Bicycles are, in my mind, a sort of a perfectly socially useful product. And they get people from one place to another. They don't pollute. They give us much needed exercise. They take up much less room on the road than cars. They're very socially useful products. But they're not exempt from the law that says if a product is created that has the potential to cause harm, then those who profit from that product's creation and distribution and sale have to shoulder the burden of paying for any harm that it causes. The economists call this observation an observation about externalities. An externality is the cost of some transaction that's not borne by the parties to the transaction. For example, automobiles. Automobiles produce air pollution. And air pollution is costly. It impairs people's health. It has many bad effects. And if the cost of air pollution is not internalized into the transaction of producing and buying and using automobiles, then it's borne by all of us because we all breathe the air, or it's borne by all of us who pay taxes because the government has to pay the costs of people who are made ill by breathing bad air. So the law of economics says that the most efficient way for this cost to be handled is for the law to require it to be internalized. That is, there should be either a tax on the sale of every gallon of gasoline that goes to mitigating the effects of pollution. There should be a requirement that non-polluting vehicles be researched and be produced. You might collect a toll for the use of a road, and part of the toll goes for the cost of mitigating the effects of air pollution. One way or another, or through some combination of these effects, the laws of economics and the common law, the law that was developed in our country to regulate industrial productive activity, says these costs have to be internalized. If you're talking about bicycles, if you're talking about automobiles, if you're talking about cigarettes, one thing we saw was that it took a number of massive lawsuits to force those who profited from the manufacture and sale of cigarettes to internalize the costs. So the lawsuit is, in our law-bound culture, a method for forcing those who profit from a certain transaction to shoulder the burdens of it, to shoulder the costs of it. So these are all examples: bicycles, automobiles, cigarettes. Keep this in mind because I'm going to come back to it later. So this brings me to, you're wondering, like, when's she going to get to the pornography part? Okay, here it comes. This brings me to my modest proposal. People are always asking me when they hear I'm talking about pornography, well, what do you mean by pornography? And that's a fair question because everyone has a different definition. You know, some people think those ads for like cheesecake and Gourmet Magazine are pornographic, and you know, that's a good metaphoric use of the term, but that's not what I mean. Here's what I mean when I'm talking about pornography. I'm talking about material that links the reader's or the viewer's sexual gratification to the infliction of violence. And in particular, here's my definition. Pornography is a depiction in any medium of violence directed against or inflicted on an unconsenting person or a child for the purpose of anyone's real or apparent sexual arousal or gratification in a context that suggests endorsement or approval of that activity, and that's likely to promote or encourage similar behavior in those exposed to the depiction. I know that's a mouthful, but every part of it is important for reasons I'll try to make clear later. So I'm not talking about what you might call erotica. I'm not talking about the stuff that you can get on some cable TV channels, at least I don't think I am. But I am talking about material, and it is out there that depicts someone hurting somebody else, inflicting pain or suffering, in a context suggests that this is sexy, that this is arousing or gratifying to the person inflicting the pain, that this is okay, this activity, and that's likely to promote similar activity in someone who has been exposed to this depiction. That's what I'm talking about. And my proposal is that if someone is harmed or believes that she has been harmed by someone who is inspired by watching this kind of depiction, then the person who's harmed has a right to bring a lawsuit against the person who created or disseminated the depiction. In the same way that if someone believes that she has been harmed by breathing in polluted air, she has a right to bring a lawsuit against the manufacturer of some of the vehicles that created and generated that pollution. Now, I know what you're thinking, like, oh yeah, the woman who spilled the coffee in her lap, the kids who sued McDonald's because McDonald's made them eat too much fatty food. There is a belief abroad in the land that lawsuits, litigation is out of control, and that we're not willing to take personal responsibility for our choices and our acts. We're always trying to put it off on someone else. And if you believe that, then you probably believe that my proposal is just another example of refusal to take personal responsibility. But here's what I want to emphasize. I'm not suggesting anything except that a victim of violence has a right to bring a lawsuit against someone who commercialized a depiction of similar activity that was consumed by another person who saw it and was moved to think, I want to do that because it's okay and because it's going to feel good. So we're not talking about a failure of personal responsibility on the part of the person who brings the lawsuit, the plaintiff. That person surely has no responsibility for what's happened to her. She's a pure victim. Now, you might think, well, what about personal responsibility on the part of the person who did the harm? Isn't my suggestion going to take away from the personal responsibility of the, I'm going to say guy, even though that's sexist, and it wouldn't have to be that way, but for shorthand purposes, I'm going to say the guy who actually did it. And here's my answer. No. No, it wouldn't. Here's why. This is an analogy. Back in the 70s, the Ford Motor Company made a vehicle, and this vehicle was notorious for exploding on impact when it was rear-ended. In particular, what would explode would be the fuel tank, and that would rapidly incinerate anyone who happened to be in the passenger compartment. Now, you understand, it's not the fault of the Ford Motor Company if someone rear-ends a Ford Pinto. There's no way you can design a car to prevent it from being rear-ended by a drunk or someone who's driving too fast or just an inattentive driver. But what you can do is design a car in a way that ensures that in the foreseeable event that it is rear-ended, because you know sooner or later a mass production vehicle is going to be rear-ended, in the event it is rear-ended, you can design it in such a way as to minimize the danger that those who are riding in the car are going to be incinerated when the fuel tank blows up. So it happened. Someone rear-ended a Pinto, the Pinto blew up, someone was killed, someone else was terribly burned. There was a lawsuit against the Ford Motor Company, and that lawsuit succeeded as it should have. That doesn't mean that the guy who rear-ended the vehicle bears no responsibility. Let's say gal in this case, just so I won't be sexist. The gal who rear-ended the Pinto bears no responsibility. Of course it doesn't mean that. She does too. The law recognizes in many situations, and this is just one example, that an actor who directly inflicts a harm can bear responsibility, but there can also be responsibility assigned to someone else for failing to take precautions, for failing to internalize the risk of a certain transaction from which that actor profited. So what I'm suggesting is no departure from the regime of personal responsibility. I'm just suggesting that the universe of those who might bear some personal responsibility includes those who create and profit from these these products. Pornography is speech, but pornography is also a product. It's sold, it's commodified. People make money, a lot of money, from making, distributing, and selling pornography. And when these materials inspire people to commit foreseeable harms, then to say that those who created this product bear some liability is simply to treat them the same way as you treat the producers of bicycles and automobiles and cigarettes. And in my opinion, that does not violate the First Amendment. But you're saying to me, well, yeah, but bicycles aren't speech, and automobiles aren't speech, and cigarettes aren't speech, but videotapes are speech. And so that's different. That's why they're different, because the First Amendment protects speech, but it doesn't protect other kinds of products. I have two answers to that. One is that actually the line between speech and non-speech products is remarkably hard to draw, it seems to me. Video games, are they more like a car, or are they more like a book? Interactive kinds of experiences often include hardware that looks like a car and software code that looks like speech. So more and more of the products that we consume, that we fill up our lives with, include both speech and non-speech components, and maintaining that distinction, it seems to me, at least for purposes of this regime of liability, is going to be difficult, if not impossible. But the second answer I would give to this point is this. In my opinion, the First Amendment says you can't make it a crime to produce a pornographic videotape, unless it's obscene, by the way, which is this whole other area of First Amendment law I actually don't plan to talk about. But you may know, if you've studied this, that the Supreme Court has said there are certain kinds of speech that are not protected by the First Amendment, like speech that defames someone, libel or slander, or speech that discloses secrets that are important to national security, or another category of speech that's not protected is fighting words, and a final category is obscenity. Well, the Supreme Court has developed this three-part test for defining obscenity, and in my opinion, that venture has just not been very successful. But the important thing is, it doesn't matter for my argument, because I'm not talking about obscenity. If some other lawyer wants to argue that obscenity is protected by the First Amendment or it's not protected by the First Amendment, I mean, I'm interested in that argument, but it's not my main point. I'm talking about something different. I'm not arguing that the law can make it a crime to produce the kinds of materials I've described. I guess it can if they fit the test of obscenity. I guess it can't if it doesn't fit the test of obscenity, but it's not important to my argument either way, because I'm not talking about prosecuting someone for a crime. I'm not talking about allowing someone to go to court and get an injunction against the distribution of certain material either. I think the First Amendment does and should make it difficult, if not impossible, for someone to go to court and get what's called a prior restraint, an injunction against the dissemination of some speech or speech-like material. I'm simply saying that when someone can prove harm, can prove damage, can prove that this was caused by a product and it was foreseeable that it would be caused, that the First Amendment shouldn't get in the way of that lawsuit. Now, many other things may and should get in the way of that lawsuit. It may be difficult or impossible to prove that the harm was caused by the pornography or the product. It may be difficult or impossible to prove that it was foreseeable when the product was produced that it would cause this harm. Those are all aspects of what's called called by lawyers the law of torts, the law of personal liability. And the law has a number of well-developed rules to address these issues of foreseeability and causation and shared responsibility. They're not perfect rules, but they're well developed. They've been developed over hundreds of years, and they're as close as we can get to a good regime for distributing the risk of our post-industrial world to the people who profit from the transactions that create and disseminate products. So I don't think this question really poses difficult issues of First Amendment or constitutional law. It does pose difficult issues of tort law or personal liability law, and many of those remain to be worked out, and they're going to be hard. But my argument is this: don't preclude the exploration and development of those rules, if you're a judge, by just dismissing every lawsuit of this sort on First Amendment grounds before there can be any exploration of these other issues that I've talked about. Consider the case of Rice versus Paladin Press. This is a case in which the Supreme Court might have, but didn't, tell us whether the First Amendment allows lawsuits like this. Paladin Press is a little publishing outfit. It's actually in my hometown of Boulder, Colorado. And it publishes sort of manly literature like things about mercenaries and a lot of stuff about firearms and weapons and things like that. It also published a book called Hitman, a Manual for Assassins, that gave very careful instructions to a person who was planning to be a professional assassin about how to carry out assassination swiftly, effectively, and without being detected. About the time this book was published, there was a man who lived in Maryland. And this man was very unhappy with his life situation because he and his ex-wife had a son who proved to have a serious handicap. And there was a lawsuit brought and a large verdict recovered because of the original cause of the son's handicap. But the son was alive and he required very, very expensive care. And the father, who was divorced from the son's mother, was required to contribute to this care. So a lot of his money went every month to care for his handicapped son. And in addition, there was a large life insurance policy on the young man's life, the handicapped young man's life, and the father was a part beneficiary of it, and he had his eyes on that money. He thought it would be very convenient if his son were to die. But he realized that was probably not going to happen as long as his son got adequate care, so he hired a professional assassin to kill his son and his ex-wife. And the professional assassin did, and in addition, killed the son's medical caregiver. The assassin was rather swiftly caught, and when he was caught, he had a copy of Hitman, a Manual for Assassins, in his car. And various features of the killings made it clear that he had followed the instructions in the assassin's manual very clearly. The assassin and the father who had hired him were both prosecuted for murder. They were both convicted. One was sentenced to death and one was sentenced to life in prison. But the survivors of the three dead victims were not satisfied with this outcome. They brought a lawsuit against Paladin Press, saying Paladin Press had some responsibility for the dissemination of this product when it was foreseeable that someone would use these instructions to carry out a killing. And someone did. So the case is set for trial before a federal trial judge, and the judge says the First Amendment does not allow suits like this. So the disappointed claimants appealed the case to the next highest federal court, which said that the trial court had been wrong, and the First Amendment does permit these kinds of lawsuits if you can prove foreseeability and causation and all the other elements of a claim in tort. So at that point, Paladin Press thinks, boy, we better get the Supreme Court to look at this question. And so they asked the Supreme Court, which has a choice whether or not to review a case like this. They asked the Supreme Court to review it. And while their request is pending, the Columbine high school massacre happened. And I think not coincidentally, not long after that, Paladin Press's lawyers offered to settle the lawsuit with the plaintiff and paid them an undisclosed amount to settle the lawsuit. So this question that I've been describing, does the First Amendment prohibit lawsuits of this sort, was on its way to the Supreme Court, but its progress was interrupted by the settlement of this case. Sooner or later, there will be another case, and the Supreme Court will address this question. When it does, I hope that it takes the view that I've just described here, although I don't know that it will. But that brings me back to Justice Thomas and his comments on the occasion of the argument of Virginia versus Black, talking about what a burning cross meant to a black man in a highly personal and apparently extremely persuasive way. What if some woman were to talk about pornography in that highly personal way that Justice Thomas spoke about cross burning? What would it sound like? Every woman would have something different to say, probably. Many of us would have different opinions in this room, I'm sure. But here's what one very eloquent woman said. I'm reading from the writings of a woman named Susan Griffin, who's written a lot about pornography and women. Suppose every gesture one made, every word, every act, signal, motion, a frown, a wave of the hand, a shout, a scream, a kick, a rush of words, each and every expression of one's psyche were ignored. Suppose that in a company of people, every time one opened one's mouth to speak, one's own words were drowned out by other words. Or suppose that if one spoke into the waiting silence, one encountered no response, no dialogue, but instead simply a stillness as if nothing had been said. This is the single most common experience that a woman has of her own real presence in the culture of pornography. Productions that suggest that women's pain is less important than the sexual pleasure of another silence women. The pornographer and his defenders claim that they fear censorship, the loss of their freedom to speak and their opportunity to be heard. But here's what I would say to them when they cry censorship. And now these are my own words and not Susan Griffin's. For women, the pornographer is the censor. He's the thought police, the slayer of words, the silencer, the burner of books, the killer of poets. He leaves in the wake of his creations a vast and terrible silence, and that is not what the First Amendment contemplates. He prevents us from saying and hearing important truths that we need to heal our troubled sexual spirits and our troubled world. Thank you again so much for having me here tonight. It's been a great pleasure. I think I'm now to set aside a little time for questions and answers, but I'm afraid some of you may be uncomfortable sitting on the floor or standing up. If you feel you need to leave, please don't feel constrained in doing that. But any of you who want to stay and ask questions, I'd be glad to talk.